convenience. Second, the CLE information will be provided at the end of the program. And finally, due to the time constraints for the program, we will not be taking questions during each presenter's segment. For those attending here in person, the speakers will be available to answer your questions during the breaks. If you are attending remotely, please reach out directly to the court and we will forward your questions on to the designated speaker. The contact information will be provided during the breaks. As you see, we have quite an aggressive program. That's why we're not going to do the question and answer period, because we've really packed it with a lot of information. Without further delay, it's now my pleasure to introduce to you our first speaker. Our first speaker from our court is Judge Lisa Forbes. Now, Judge Forbes has been with us for a couple of years now. It's kind of hard to say that, but she was elected on November 3rd of 2020, and she hit the ground running that year. So you are coming up on 2 years. Wow. It's been wonderful to get to know her. Prior to joining the bench, Judge Forbes was a partner in the Cleveland office of the law firm of Voyer, Saters, Seymour, and Pease, where she practiced in the area of complex litigation. As a litigator, Judge Forbes represented clients in the state and federal trial and appellate courts throughout Ohio for 27 years. Throughout her career, she's been active and engaged in a member of the Northeast Ohio community, including serving on the boards of the Center for Families and Children and Circle Health for over a decade. She currently is vice chair of both boards and chair of the Quality Improvement, Risk, and Program Committees. In addition, while practicing, she regularly wrote and presented on developments and on application in the law. She graduated summa cum laude from Case Western Reserve University of Law School in 1992. She has served first as an associate editor of the Law Review and then as an executive notes editor. She majored in public policy at Cornell University and has a bachelor's of science degree. Now, I asked her just before we came on here one fun fact of herself, and her fun fact is she fulfilled a lifelong dream of hiking in the Grand Canyon this summer, and she lived to tell the tale. So, without further ado, Judge Forbes.
Well, good morning, everybody. And I have to say it's a smidgen misleading to say that I'm going to be the first presenter, because I'm actually have the good fortune of being on a panel with Tony Farkas and Newton Cargill, two of the longest serving judicial attorneys at the Court of Appeals. Newton is a judicial attorney working now with Judge Emanuela Groves. Previously, he worked with Judge Pat Blackman, and he's been at the court for years. And Tony Farkas is a judicial attorney now with Judge Eileen A. Gallagher. And previously she worked with Judge Kenneth Rocco. So not only are these two of the sharpest legal minds that we have at the court, but I just want to warn you that if either Tony challenges you to a foot race or Newton suggests you should just go play a round of golf, you should be forewarned that they are both exactly as skilled at those avocations as they are at their vocation. So with that, 1 second, I'm going to grab my water. All right. So the first topic today, we have titled our presentation as "Can You Fix It?" And the topics we're going to go over are, and I'll get into the specifics of them in just a second, I'll focus really on what can you do as opposed to what can the court do. What can you do before you even get to the court of appeals that can make your sailing there a little bit smoother. And then that's going to be my part, talking about final appealable orders and ways that you can fix a trial court's order to ensure that you can stay in the Court of Appeals. And Tony's going to talk a little bit about ways in which you can maybe fix a trial court order without coming to the Court of Appeals. That's doing a deep dive into non-protunks. I know everybody's like, thank God, I've always wanted to know. Then Newton is going to talk a little bit about how do you fix a trial court order without appealing by looking at 60B. And again, that'll focus on Civil Rule 60B. And then lastly, time willing, we'll talk just a smidgen about motions for reconsideration, and you'll hear about en banc motions later in the day. So here you go. Can you fix it? Remember this guy? Very inspiring. So the importance of final appealable orders. This isn't going to come as a shock to any of you. This is an advanced appellate advocacy seminar. But you can't come to the Court of Appeals unless you have a final and appealable order. And that's because our jurisdiction is limited. The Ohio Constitution specifically says that we can only review final orders. So we don't have discretion. And we can't do anything with a trial court's order that isn't final. We just have to send you back. So you look to 250502 to understand what is a final order, of course. And the simplest and easiest way to think about it, and what I'm really going to focus our look today at, is going to be on the notion that a final order is one that disposes of all claims against all parties. That's really just the simple formulation of the more artful statutory definition of affects a substantial right that determines the action and prevents a judgment. Of course, there are other ways in which final orders can be created. I'm just going to throw them up on the screen here. But again, we're just going to focus today on this really idea of when have you disposed of of all claims against all parties or affected a substantial right determining the action. So before we get on to some of the more civil aspects of things, because I was a civil practitioner, so I apologize to the criminal practitioners out there. There is one thing to pay attention to in particular with regard to matters in criminal actions that relate to final appealable orders. You must have your one document that articulates not only the fact of conviction, but also the sentence. And that comes from two Supreme Court cases, Baker and Lester. Tony's going to talk a little bit about how to fix it if you don't have one final order. But I already, in my brief tenure on the court, I have already seen cases where they're fully briefed. Only the appeal has been fully briefed, only to realize at oral argument, oh, one of the counts hasn't been disposed of. So, you have a journal entry addressing 30 out of 30 counts in the indictment, announcing the fact of conviction. And then lo and behold, count 29 was never sentenced. There's nothing we can do. It has to go back. So don't let that happen to you. You can take care of it at the trial court. So you don't have to do it twice, the Court of Appeals. Now, just real quickly, not going to belabor these points, but of course, the denial of a 12B6, a Civil Rule 12B6 motion to dismiss is not a final appealable order because it doesn't affect a substantial right that determines the action. In other words, doesn't dispose of all claims against all parties. There are, of course, special rules regarding some discovery orders. We're not going to dwell on those today, though, but do remember that. Oops. Sorry, it's not moving forward. There we go. Denial of summary judgment. Remember that generally speaking, that is not final and appealable. Again, doesn't dispose of all claims against all parties, but where immunity is at issue, that is final and appealable. You don't need to do anything to get to the Court of Appeals. At the conclusion of a case, sometimes denial of summary judgment is going to be final and appealable, but usually not. It's only final and appealable if you're dealing with a purely legal question that hasn't been rendered harmless by a subsequent trial on the merits. So what if you do have a summary judgment ruling that involves multiple defendants and the trial court only grants summary judgment against one? or you have multiple claims and the trial court only grants summary judgment on one of the claims. I'm sure all you civil practitioners out there are thinking, I can fix that. The Rule 54B order, 54B entry, just ask the trial court to give you your no just reason for delay ruling. Well, what we're going to talk about here today is going to be a little bit about things to be cautious of to ensure that you get your 54B ruling correct and when it is that you need your 54B ruling. 54B, you can see the language up there. 54B is for the general purpose of accommodating a strong public policy against piecemeal litigation and weighing that against the possible injustice of a delayed appeal in certain special situations. And I bring that up because it's not always available. So 54B language is necessary. You cannot bring an appeal of fewer than all claims against all parties to the Court of Appeals without the magic language, no just reason for delay. Oh, but wait, did I just say magic language? Is it magic? No, in fact, having those magic words won't necessarily make your 54B appeal appropriate. We do still review the 54B designation. And we have to, because as I said at the outset, it's jurisdictional. So really, there are two questions you have to answer to understand whether 54B language appropriately applies. The first is it final under 250502? And you're probably thinking, wait, didn't you already say it has to dispose of all claims against all parties? Here, when we say final, we mean within a unique, distinct branch of the case. So the question that we look for under when we're doing a 54B analysis is, did the trial court's decision fully resolve of any of the appellant's claims? So using the words of 250502, does the order affect a substantial right that determines an action and prevents judgment? So we look at that in the narrow context of the specific question put. And then the second question is, has the trial court correctly determined that 54B language was added that there is appropriately no cause for delay, no just cause for delay? And to assess that, courts look at whether the interests of judicial economy are going to be served by an immediate appeal. So let's look at this in practice. And those tests, I would like to lay claim to them, but that's not me, that's the Ohio Supreme Court. What if a plaintiff claims that the defendant has been drag racing? He causes a motor vehicle accident. He sues for negligence and loss of consortium. He requests compensatory judgment, punitive damages, and attorney fees. The trial court grants summary judgment on the punitive damage and attorney fees claims for relief and knocks those out. The court says there's no genuine issue of material fact on whether the defendant was drag racing. So there's no malice, but the negligence and loss of consortium claims remain. So the question is that a final appealable order? No, I see a number of you shaking your heads. No, it's not a final appealable order. Now, the next question is, the trial court actually added this language, partial. There is no just reason for delay. Is that enough to allow the question to remain in the Court of Appeals? And I see many of you shaking your heads no. And you're right. It is not enough. It's not enough because the partial journal entry there did not resolve any of the appellant's claims. Negligence and loss of consortium remained. And so addressing those two potential measures for relief did not render that a final journal entry. So we couldn't look at it. And this is a case, as you can see the site there, that had to go back. Let's look at another scenario. What if you have John Doe defendants? John Does are oftentimes sort of confounding, right? Here we had a case, here's a scenario. You've got a complaint for medical malpractice against one named individual and 10 John Does. Trial court grants summary judgment against the named individual, dismissing him from the case, and the plaintiff tried to appeal in a timely way. Can the plaintiff appeal?
Maybe.
Oh, we got a ringer over here. That's right. That's right. Any yeses that he can? Any no's? And now, no. Yeah. So the question is, do you want more information? All right. Well, here's a little bit more information. The plaintiff did not ever amend the complaint to identify any of the Doe defendants and did not serve any of them before the summary judgment was granted. Is that enough to answer whether 54B language can fix this? Yep. And those of you like Judge Boyle, who said maybe, I'm going to agree with you. And in fact, so is the 8th District Court of Appeals. Here, the more than a year had passed. So the complaint was filed, more than a year had passed, no does had been identified, so no does had been served. So they were not properly before the court. The case had not commenced as related to the Doe defendants, so that when summary judgment was granted as to the individual doctor, that was a final and appealable order addressing all claims against all parties properly before the court. No 54B language was necessary and the appeal could go forward. What if less than a year had passed? Any thoughts? Well, if less than a year, pardon?
You have a finality problem.
You have a finality problem if less than a year has passed. And that's because those does could still be identified and they could still become parties to the case. And so you do need 54B language depending on the amount of time that has passed. Or I should say you may. Now, getting the 54B language may not be your only solution in that situation if you have unserved defendants or if you have served defendants, right? Depending on the amount of time. And that other solution, possible solutions, you might be able to dismiss those unserved parties or the other parties. But you have to remember here that you can only dismiss parties, not claims. So this doesn't work. This dismissal doesn't work for claims to make a final appealable order under Civil Rule 41. The proper way to dismiss fewer than all claims is to file an amended complaint under Civil Rule 15. So just real quick, I'm not going to belabor all these reminders, but I do want to remind you that reconsideration of a summary judgment, if that summary judgment does indeed dispose of all claims against all parties, does not toll your time for bringing your notice of appeal. It is a legal nullity. So you can ask, but if that summary judgment disposed of all claims against all parties, your 30 days are running and the trial court doesn't have jurisdiction anymore. So if in fact all claims have been resolved against all parties, you need to come to us to get your quote fix. And so now I'm going to turn it over to Tony and thank you very much.
Hi, good morning. I'm going to talk a little bit about the use of NonProtunks to fix errors and omissions by the trial court. You might think that NonProtunks are fairly rare, but actually we see them with some frequency in the appellate courts, at least our court. The last time I did a check on Lexis, there were over 6,000 Ohio appellate cases referencing NonProtunks, so they're actually a little more common than you might think. I'm going to go over some of this material fairly quickly. So if you find that this is an area in which you have an interest, I'd encourage you to look at the written materials because the written materials go in a little more detail about these NonProtunks. So get started. So what is a NonProtunk? NonProtunk is Latin for now, for then. It's an order that's issued after a prior order that seeks to correct some clerical error or omission in the prior order so that the record speaks the truth. The sources of authority for NonProtunk orders, you'll see that common law in the civil rules, you can find it in Civil Rule 60A, and in the criminal rules, you'll find it in Criminal Rule 36. And I'm not going to read all these rules. Yeah. So what's the effect of a proper NonProtunk entry? Why does it matter? Going back to that now for then, a proper NonProtunk entry has the same legal force and effect as that prior order. It relates back to the original entry, and as a result, it generally doesn't have an effect on the time for appeal. Now, there are some exceptions that's been recognized over time. Just because a non-protunct fixes a clerical error doesn't mean it might not have significant consequences. There may be certain circumstances in which a non-protunct properly changes a sentence, where it adds a couple of zeros to a judgment, or something else. And so in those circumstances, there have been instances in which an exception has been recognized, where a non-protunct affects a matter of substance, or creates additional rights, or denies an existing right. It may extend the time for appeal. So what's the effect of an improper non-protunct? It doesn't have any effect. It's invalid. It's void. So from an appellate perspective, I said there's, we do have quite a few instances in which these pop up in appellate cases. Why does it matter? Whether or not a non-protunct entry is valid may determine whether a final appealable order exists. It may affect the time for appeal, and it could determine what the substance of the order that's being reviewed on appeal. The court speaks through its journal entry. So knowing what that journal entry is, whether it's the original journal entry or the journal entry changed via the non-protunct, matters. So how can error be corrected via a non-protunct? It can be done sua sponte by the court, or it could be requested by motion by a party. So now we're at what errors can be corrected via a non-protunct entry. They can be used to remedy clerical mistakes. You see that term used in the rules, in judgment, orders, or other parts of the record. So what's a clerical mistake? A common definition is a mistake or omission that's mechanical in nature and that's apparent on the record, that does not involve a legal decision or judgment. Although it's called a clerical mistake, it's not limited to mistakes by a clerk. You often see errors in mathematical calculations or typographical errors. Those are common clerical mistakes. In addition to clerical mistakes, non-protuncts may also remedy errors in the record arising from oversight or omission. Again, that goes back to the language that's in both Civil Rule 60A and Criminal Rule 36. And that's basically something that's omitted from a journal entry that was in fact done or decided. So something that was done that just got omitted. So what errors can't be corrected via a non-protunct entry? My judge, Irene Gallagher likes to say, I'm quoting her here, the trial court could not nunk what it did not first tunk. So have to give credit where credit is due for that one. So in other words, non-protuncts cannot be used to supply omitted action to do what the court should have done or intended to do, but did not in fact do, or as a vehicle for changing the court's decision. So how do you determine whether something is a proper non-protunct that reflects what the trial court actually did or decided, or is an improper non-protunct, where it's a mean by which the trial court's trying to change its decision or correct a judicial error? Look to the record in the first instance. If you look at the definition of clerical mistake, it talks about a mistake, omission that's apparent on the record. So unless you have something that's tangible in the record, you can point to showing that there's a clerical mistake or omission, you're probably not going to have a valid non-protunct. That being said, when you look at the case law, some courts have also considered the context and the surrounding circumstances and whether something makes sense when you're evaluating whether a non-protunct entry is proper. So we did the how, the what, now we're at the when. When can a judgment or order be corrected via a non-protunct entry? If you look at the language of both Civil Rule 60A and Criminal Rule 36, you'll see the language says at any time. But does any time really mean at any time? What about while an appeal is pending? Civil Rule 60A specifically addresses that circumstance and says that during the pendency of an appeal, mistakes may be so corrected before the appeal is docketed in the appellate court and thereafter while the appeal is pending with leave of the appellate court. You'll notice that Criminal Rule 36 is silent on that issue, but courts have looked to Criminal Rule 57B, which states that if there's no rule of criminal procedure that addresses a particular issue, you can look to a rule of civil procedure to fill that gap. Courts have also used Appellate Rule 9E as a basis to provide authority to issue a non-protunct to correct a clerical error or omission while an appeal is pending. And I know that our court has at times remanded cases back to the trial court to issue a non-protunct to fix a very obvious error that is noticed when a case comes in so that an appeal can proceed. And that sort of addresses the circumstance that Judge Forbes mentioned about the fact where you're looking at it and you see, oh, a sentence hasn't been, a count hasn't been sentenced, and our court notices that. It may be a circumstance in which the case is remanded back to the trial court to issue a non-protunct, if in fact that count had been previously sentenced on at the sentencing hearing and just didn't make its way into the sentencing journal entry. Where you don't have a remand by the appellate court, jurisdictional considerations may limit the ability of the trial court to issue non-protunct entries while an appeal is pending. As you may know, it's well established that once an appeal is perfected, the trial court's divested of jurisdiction over matters that are inconsistent with the reviewing court's jurisdiction to reverse, modify, or affirm a judgment. And a number of courts have applied this to non-protuncts. I mean, this just makes sense. You don't want to have the appellate court reviewing what it thinks is the substance of a particular order, and then the trial court comes in and modifies the substance via a non-protunct. So, I mean, that just makes sense. Sometimes courts will say it depends on what's being corrected and what is being appealed in determining whether or not there are jurisdictional issues at play. What about after an appeal? It's not uncommon to see non-protuncts being ordered, a case being remanded for the issuance of a non-protunct as part of the relief granted on appeal. We see that with some frequency with regard to sentences and sentencing journal entries where something was in fact done and it's just not reflected in the sentencing journal entry. With regard to other post-appeal non-protunct entries, you're back to that language at any time, but again, there may be some limitations. For example, you can't issue a non-protunct entry correcting a sentence after the sentence has already been completed. All right. So we thought that the best way to look at some of the do's and don'ts of non-protuncts would be to go through some examples. I can't promise you that this is going to be as exciting as Michael Sheehan on the $800,000 pyramid, and I don't have any money to offer you, but hopefully this will make it a little more fun. All right. So example number one. The trial court issues a non-protunct entry to correct the filing date where a petition for post-conviction relief was received by the clerk's office on August 2nd, but was file stamped August 3rd. So a non-protunct entry is issued to correct the filing date to August 2nd. I'm not going to call on anyone, but by a show of hands, who thinks you can fix it with a non-protunct? Who thinks you can't fix it with a non-protunct? Well, at least based on this case, this example is from the case listed there, State versus Miller. It's sort of a quintessential example of what's considered a clerical error. And so you could fix it with a non-protunct. All right, example number two. A trial court originally dismisses a case with prejudice, and then it issues a non-protunct dismissing a case without prejudice. Who thinks you can fix it with a non-protunct? Who thinks you can't fix it with a non-protunct? Overwhelming majority, as you see, it's not something you can fix with a non-protunct. That being said, unless there's something in the record that specifically shows that the trial court had actually decided to dismiss the complaint without prejudice and then to do some clerical error and inadvertently dismissed it with prejudice, this is a substantive change. It's the court changing its mind. It's a judicial error. All those things that you can't use a non-protunct for. Doesn't matter if it's the other way around and the trial court first dismisses a case without prejudice and then seeks to dismiss the case with prejudice. No. But I did want to point this out because this is an example of when you have a valid non-protunct can affect whether you have a final appealable order. A dismissal with prejudice is usually a final appealable order. There are some exceptions, but a dismissal without prejudice is usually not a final appealable order. So if your non-protunct order dismissing a case with prejudice is void, you may not have a final appealable order. So that's one of just the reasons why non-protuncts can actually be very important. Okay, example 3, sort of looking at what Judge Forbes talked about earlier about 54B language. The trial court issues a non-protunct adding Civil Rule 54B language to a prior order while an appeal is pending. All right. Can you fix it with a non-protunct? Can you not fix it with a non-protunct? This comes from the case Step versus Sterrett. And in that case, there's actually 2 issues that they raised. One is the fact, it goes to the adding of the 54B language. A non-protunct, 54B is actually a determination akin to a factual determination. Is there no just reason for delay? So it is a substantive determination. And this is a circumstance in which a non-protunct cannot be used to supply omitted action to indicate what the trial court should have done or decided it didn't do. And then you have the other issue that this was while the appeal was pending. And again, that court said that, the trial court lacked jurisdiction to issue the non-protunct while the appeal was pending. I will say that doesn't mean that it couldn't be fixed. Because the original order without the 54B language was interlocutory, once the appeal was dismissed and remanded back to the trial court could then issue a subsequent order adding the 54B language. So this is a circumstance in which, one fix might not work, but another one might. I will tell you, there are some cases in the materials that do say that you can add 54B language via a non-protunct. But when you look closely at the analysis in those cases, really, it seems to be what they're saying is that you can have a subsequent order that adds 54B language, not that order is a true non-protunct entry. And you wouldn't want it to be a non-protunct entry because then it might affect your time for appeal. So it could shorten that. What about if the trial court issues a non-protunct order seeking to delete 54B language? Can you fix that with a non-protunct? Who thinks yes? Who thinks no?
Only if the court said, no, I'm not issuing a 54B language from the beginning.
I think Dave's hit it right on the nose. Once again, unless you've got something in the record you can point to, it's not going to be a proper non-protunct. That's based on that Infreus case that's cited there. And they say that where there's nothing in the record to indicate that this was what the trial court had previously done, you can't strike that language and make your judgment less final via a non-protunct. Okay, one final example. We talked some about sentencing issues, so I thought this might be a timely one. It's based on a case that the Ohio Supreme Court decided a couple months ago. At the sentencing hearing in 2003, the trial court properly sentenced a defendant to a mandatory term, a 5-year term of post-release control. The original sentencing entry did not specify that mandatory term of post-release control. And then in 2020, following a motion by the state, the trial court issued a non-protunct entry to reflect that the defendant was subject to that mandatory term of post-release control. So here you go. You can see the added language at the bottom. That's all they added via the non-protunct. 17 years later. Can you fix it with a non-protunct? Who thinks yes? Thinks no? All right. The Ohio Supreme Court said, yes, you could do that. In this particular case, the defendant had filed a mandamus action seeking to compel the trial court to vacate the non-protunct entries, arguing that since the original sentencing journal entry did not properly impose post-release control and the state did not appeal, that they should be precluded from by res judicata from seeking to correct that error via a non-protunct. But in Randlett versus Lynch, the Ohio Supreme Court said where a valid non-protunct entry can be issued under Criminal Rule 36, res judicata does not preclude its use, which to me was sort of surprising given the whole Harper Henderson Bates line of cases. But they said a proper non-protunct entry is not a collateral attack on the judgment it corrects. And so it could be done. So I'm going to turn things over to Newton, who is going to talk about another means by which you can fix it via Civil Rule 60B.
Good morning. Thanks for coming out. My segment, 60B, intends to strike a balance between finality on the one hand and perfection on the other. Finality means that we want an end to litigation. On the other hand, we want a just result. So you have two competing parties. You have this party over here that has a final judgment and wanted to stay. You have, at the other end, you have this party that says, no, I want that to be unraveled. So we'll come to 60B. So what does it say? On motion, so it has to be by motion. The court may relieve a party from a final judgment for the following 5 reasons: mistake, newly discovered evidence, fraud, the judgment has been satisfied, or any other reason. Now, the key here is it has to be filed, the motion has to be filed within a reasonable time. And for the grounds 1, 2, and 3, it has to be filed no later than 1 year from the time of the final judgment. With 4 and 5, reasonable time, and we're going to get into some of that, the nuances of that. The other thing to keep in mind is that it does not affect the finality. So the clock keeps running. So your appeal time keeps going. Now, what type of things are subject to 60B? It has to be a final order. Final appealable order, and as Judge Forbes discussed earlier, it is not applicable to interlocutory orders. It is not applicable to voluntary dismissals, and it is not applicable to appellate proceedings. Now, a trial court is vested with broad but not unlimited discretion to grant or deny, to grant a motion for relief. Now, how do we review it? We review it for abuse of discretion. And as you know, an abuse of discretion occurs when a decision is unreasonable, arbitrary, and unconscionable. Now, is a 60B motion a substitute for an appeal? No, no, no. The other question is it used as a substitute for an appeal? All the time, right? No, it is not a substitute for the appeal, but it is used a lot as a substitute for the appeal. And in those instances, when generally the moving party misses the deadline to file their appeal, they file a 60B motion. And that gets denied. And it gets denied because it doesn't get granted. It doesn't get granted because they're arguing the same things that they would argue in a direct appeal. So if you file a 60B motion as a substitute for a direct appeal, res judicata applies, right? So the key is that you need to file your direct appeal. Now, some people, there might be a 60B motion that is pending when you file your direct appeal. In that case, you're going to need a limited remand. But later in the program, Jake Dykers is going to discuss more on that. So I'm not going to touch on that at all. The leading Ohio Supreme Court case on 60B continues to be GT, right? On the GT sets forth 3 things that a person seeking relief has to demonstrate. 1, they have to demonstrate a meritorious defense or claim to present if the relief is granted. 2, that they are entitled to relief on the 1 of the 5 grounds. And 3, that they have filed this within a reasonable time. All 3 have to be filed within a reasonable time. Now, as to a meritorious defense or claim, the key with this is that the meritorious defense or claim, it doesn't have to show that you're going to succeed, but it just has to give the trial court some idea that, hey, look, you know, this is worth vacating this order, right? So you have to specify operative facts. The more you can put in to show that you are entitled to relief, the better. So put in as much as you can, right? You can't just deny things and expect that you're going to get relief. You won't. Now, when it comes, I need to click, right? Okay, reasonable time. What is this reasonable time? The reasonable time, they're like two different standards. So when it comes to grounds 1, 2, and 3, the reasonable time, but it has a 1-year limitation. When it comes to grounds 4 and 5, it's just reasonable time, the 1-year limitation doesn't apply. However, 60B is equitable in nature. So you have to be diligent to be entitled to it. So you could like file a motion for relief on the 1, 2, or 3, and you file it, you know about the grounds 2 months after the final judgment. But you wait until 5 days before the 1 year expires. The court is going to say that's not a reasonable time. Right? So the key is that you have to move quickly. Now, as to the meat and potatoes of the different grounds, on the ground 1, mistake, inadvertent, surprise, excusable neglect. That, as I said, you have to file that within a reasonable time, but no later than 1 year, right? And you must set forth operative facts. Now, we all understand mistake, inadvertence, surprise, but this excusable neglect, the Supreme Court has termed that an elusive concept. So it's going to be based on case-by-case scenario. Recently, in May, from the 4th District, Itels Towing, and that's 2022 Ohio 1639. The 4th District held that the trial court did not abuse its discretion in granting defendants motion for relief from a default judgment on the 60B1 because defendants' neglect was excusable because of the problem created by the pandemic. It went on to say the cause of the neglect was a result of a unique pandemic over which defendant had no control and which caused significant difficulties on a worldwide scale. So you see that excusable neglect is indeed elusive, right? What about a hearing? Does the trial court have to hold a hearing? Well, that depends. If the okay, I keep forgetting to do this, you know. Okay. And you know I can't even see what's up there. Okay. All right, so that's my usual excuse to when I'm golfing, I can't see. But they don't believe me. So it depends. If the motion for relief is accompanied by operative facts, and the trial court can look and see that, yes, you know, I should undo this final judgment, then yeah, hearing. If they can look at it and there's nothing there that shows that they should grant it, then they don't need to have a hearing. So the key again is you present facts, facts, facts. Then I've presented some examples, right? And I believe, yeah. And I'm going to have you look at that at your leisure. Number 2, newly discovered evidence. Again, this one has to be filed within a reasonable time, but not to exceed 1 year. Now, the key is that it is newly discovered evidence. So it is not anything that you knew about before the final judgment. So it has to be new, right? Not going to go into that example, Stratt versus Pelton, but that's a very good read. Number 3, fraud. Again, it must be brought within a reasonable time or 1 year, but not to exceed 1 year. The person moving for relief as a burden, right, of establishing the fraud. The key here too is that fraud or misrepresentation constitutes sufficient grounds to vacate the judgment, right? Interesting note, while a litigant's false statement may justify release from judgment, unless a party relied on that, then they're out of luck. Satisfaction, right? The 4th ground, this one, has to be filed within a reasonable time. The 1 year limitation doesn't apply, right? But you still have to keep in mind that you want to file things as soon as you discover a ground. Now, the staff note indicates that on the 60B4, relief would most likely work to afford relief from the operation of a prospectively operating judgment, such as an injunction, right? So it's not anything that happened before the final judgment. That's the key to keep in mind. Then number 5, any other reason justifying relief. Now, this one is where a lot of people who didn't file their motion for relief on the 1, 2, and 3, and the 1 year has passed, this is where they go to. But guess what? Yeah, you can tell, right? The caveat is the 5th ground, any other reason, is limited to the reasons other than those set forth in 1, 2, 3, or 4. So it's termed the catch-all provision, and it reflects the court's inherent power to relieve a person from the unjust operation of a judgment. Now, the grounds for invoking and getting relief on the 60B5 has to be very, very compelling. So it's just any little thing is just not going to work. So it is construed very narrowly. So and again, the main thing is it applies only when a more specific rule ground for relief does not apply. All right. So that, my friends, is a quick snapshot of the 60B. All right. Thank you so much again for coming.
All right, wonderful, wonderful, wonderful. I encourage you to read the written materials that is in the program. As you see, they did an overview, and then they did a lot of work to put in and prepare those written materials with the case law cited. I am not Judge Eileen T. Gallagher. However, it's my honor to introduce our next speaker in our next panel. Hot topics in the law, and I'm here to present Judge Michelle Sheehan. Michelle Sheehan was elected to the 8th District Court of Appeals in November of 2018. So, another highlight. Today, you're going to see a lot of our newest judges who haven't finished their first terms yet presenting or introducing. And we did that on purpose so that everybody can get to know the new faces of our court, not just on the day of oral argument. Anyway, Judge Sheehan, prior to being elected to the Court of Appeals, was a shareholder at large at a large litigation firm, that being Reminger and Reminger. She has litigated cases in both state and federal courts on behalf of both plaintiffs and defendants for over 25 years. She is one of 28 attorneys throughout the state of Ohio who is certified as an appellate specialist by the Ohio State Bar Association. She has represented clients in appellate matters before the Ohio Supreme Court, the Sixth Circuit Court of Appeals, and almost every appellate district in the state of Ohio. She has served in various leadership roles within the community. She is the former president of the Ohio Women's Bar Association and has held various leadership roles in local organizations such as the Cleveland Metropolitan Bar Association, the YWCA, and Cleveland Marshall College of Law and Rocky River Civil Service Commission. She earned her bachelor's degree from Miami University of Oxford, Ohio, and her law degree from Cleveland Marshall College of Law, where she met her husband, the Honorable Brendan Sheehan. She is also a member of the Florida Bar. As a side note, one of the reasons our court likes to put this seminar on, and it's entitled Advanced Appellate, is because there's not a lot of seminars that focus just on advanced appellate law. We have been approved by the Ohio State Bar Association for these credits. So if you are going for your appellate specialist, these CLEs will qualify. One fun fact about Judge Sheehan is she's a secret wedding planner. Not only can she preside over weddings and perform them after special assignment from the Ohio Supreme Court chief, she also likes to secretly prepare them. And I have to say, she's a quite organized jurist who is an extraordinaire, I think you said, of various things. With that, her group is going to present hot topics. The first one being, are you sure you want to attach that? An appellate perspective on Civil Rule 12 and how to avoid reversal on appeal. Thank you.
Reminder everyone, I'm a little organized, and if you want to be married, anytime we have one on Monday, I know someone in Common Pleas Court, we could do a double wedding, it'll be great. But thank you, Judge Boyle. Today we're gonna mix things up with hot topics. We're gonna make it really easy for you though. So 20 minutes, we'll give you the highlights on 3 up and coming areas. We've been watching trends in the Court of Appeals, and over the past 2 years, there's been a few that we think are important, and that hopefully if you just take a few tidbits away from this, you can hopefully prevent you from making a few mistakes. We're going to cover 2 civil procedure rules and en banc. En banc will cover both civil and criminal. But the first one is Rule 12. By a show of hands, if you're willing, how many people have been involved in a decision that's been reversed by the Court of Appeals involving a 12B? If you're so inclined. And I know in Zoom land, there's a few more out there. It's a trend we're seeing, and we're going to talk a little bit about that. I don't know if COVID was a factor, but during COVID, it seemed to me a lot of the trial courts were granting a lot of 12B, 12Cs, and practitioners were attaching things that you didn't typically see. So for example, if a case was resolved in domestic relations and then some of those same issues got filed in Common Pleas Court, they would attach the domestic relations opinion to that complaint or to that motion to dismiss, and it would get granted. Well, we're limited. We can't look outside the pleadings, and that's what we're going to cover today. So hopefully you'll hear, I was smart enough to bring in some veteran practitioners who deal with this on a daily basis, and you're going to hear from them. So first up, we have Melissa Geist, who was in Thompson Hines Business Litigation Unit before she came to join us at the Court of Appeals and was a judicial attorney. And now she's at Flowers and Grube, and the name partners are in the audience, so there's no pressure today. You'll be fine. She's also a case grad and an adjunct professor on appellate practice as well. We also have Alex Frondorf, who's with Littler Mendelson and focuses on employment law. He also was a judicial attorney for the Honorable Ann Aldridge and Kathleen O'Malley in the Northern District some time ago, and is also an adjunct professor both at Cleveland Marshall and Bowling Green. So with that introduction, would you please help me welcome Alex and Melissa? And I'm just going to hang out here and pipe in every now and then, but really, you're in charge of the slideshow.
Thank you, Judge Sheehan. As Judge Sheehan just mentioned, we're going to focus on just a couple rules, one of them being Rule 12 and its various permutations, but also starting with Rule 8 and Rule 10 to lay some background, because that will come to bear on how we view Rule 12. And then finally, what happens when you don't answer the question right, or you're sure you want to attach that conversion from Rule 12 to Rule 56. I'm going to hand over to Melissa for the first couple slides.
All right, now before we get into the issues that come up with 12B6 and 12C motions, it's important to understand what exactly is a pleading. So Civil Rule 7A tells us that a pleading is a complaint, an answer, and responses to counterclaims and cross claims and third-party complaints. As you all know, that again, this is an advanced seminar, but a complaint must only state a short and plain statement of the claim here in Ohio. And answers need to admit or deny the allegations and state a short and plain statement of the defenses. Where it gets a little bit more tricky is the attachments to the pleading. So Civil Rule 10C tells us that written instruments that are attached to a complaint, and sometimes an answer, which we'll get into later, are also part of the pleadings. So
say that again, a written instrument. You can attach something to an answer, and that's part of the pleading.
yeah, so a written instrument attached to a pleading is part of the pleadings. So it gets into a little bit tricky when we get into what exactly a written instrument is, which we will talk about a little bit later.
So Judge Sheehan mentioned Rule 12 is taking all the spotlight this morning. And the two rules that we want to focus on within Rule 12 are Rule 12B and Rule 12C. Most of you are probably most familiar with Rule 12B6, and you would file that when the plaintiff is filed, you would file it as a defendant. When the plaintiff has filed a complaint that fails to state a claim upon which relief can be granted. And it must appear on the face of the complaint or its attachment. Beyond a doubt, the plaintiff cannot prove any set of facts to support his or her claim, which would entitle that plaintiff to relief. Now compare that to Rule 12C, judgment on the pleadings, which after the pleadings are closed, but within such time as cannot delay the trial, the party may move for judgment on the pleadings. So what are the differences between these two? Well, first, 12B motion is filed prior to the defendant filing an answer, typically. Plaintiff could always choose to amend the complaint as a matter of right, depending on the timing after a 12B6 is filed. So the plaintiff has a shot at getting out of the motion to dismiss if he or she can amend the complaint in such a way as to avoid the pitfalls that were brought to the court's attention in the motion to dismiss. Now compare that to a 12C motion. Unlike a 12B motion where it is the defendant bringing the motion, in a 12C motion, any party can bring that motion. And so if the defendant's answer either fails to assert critical affirmative defense or admits or fails to deny certain key allegations, a plaintiff can then bring a motion for judgment on the pleadings to a 12C. The 12C motion, unlike a 12B motion, can only be made after the pleadings are closed. So after the answer is filed, unlike 12B. And in a 12C motion, once the pleadings are closed, the plaintiff is locked into his or her complaint and can then only amend the complaint with leave of court. We most often see a 12C motion filed for matters like declaratory judgment or breach of contract claims, when the defendant would have the opportunity to attach a written instrument to the answer, which then becomes, as Melissa mentioned, part of the pleadings. So when do you attach and what do you attach? Making a Rule 12 motion, it really depends. Is it 12B? Is it 12C? What party are you? What is the document that you seek to attach? And when you attach it? And now we're going to get into those details. So it depends. Melissa?
So while regardless of whether you're following 12B6 or 12C and whether the attachments to those documents themselves are written instruments, attachments to the motion to dismiss themselves are not part of the pleading. So if you include attachments to your 12B6 motion or 12C motion, the court is likely to convert that motion to a motion for summary judgment. So a great example of this is the case Heck versus Equity Trust Company. In this case, the plaintiff brought a breach of contract claim, but didn't actually attach the complaint. Didn't actually attach the contract to the complaint. Now, the complaint vaguely referenced that a contract that was formed in a particular year, but didn't provide any details about, that details that would identify the complaint itself, the contract itself. The defendant filed a 12B6 motion to dismiss attaching the complaint. Attaching the contracts. And the 8th District said that that was not allowed, right? The contract wasn't attached to the complaint, and because it wasn't specifically identified in the complaint, the complaint didn't incorporate the contract, and the court remanded for the trial court to convert the motion to dismiss to a motion for summary judgment, giving the parties an opportunity to submit additional summary judgment evidence if they had to. One of the requirements for converting a motion to dismiss to a motion for summary judgment is to give the parties notice and an opportunity to respond or present additional materials.
Melissa, you said the complaint reference. We see that a lot. People in their complaint will say they reference a docket to a case in California, and then they say, well, it's incorporated into the complaint. Well, it's not. So have you had any experiences? What can they reference and it truly be incorporated? Does it have to be attached, or are there some things maybe that they could reference that are still allowed?
Well, that really comes down to the definition of what is a written instrument.
Okay.
Which might segue nicely. Not quite. Hold that question.
Okay. I'll put a
We're
pin
gonna
in
get
it.
into that in much more detail. So I mentioned Civil Rule 10 earlier. So if your complaint is based on a written instrument, like a contract, for example, in a breach of contract case, if you actually need to attach that written instrument to the complaint. But if you don't, it doesn't render your complaint invalid. So the proper remedy wouldn't be a 12B6 motion to dismiss. Instead, it's actually a motion for a more definite statement under Rule 12. Has anyone filed one of those motions? A handful. That's more than I expected. It doesn't seem to happen all that much.
So finally, we get to the question, what is a written instrument? Written instruments are documents that show a party's rights or obligations, like an insurance policy, a lease, a promissory note, or a contract. So it is a document that lays out clearly one or both parties, perhaps, rights for a given issue. The attachment must be a written instrument to be part of the pleadings. And that requirement comes from Rule 10, which we saw before. And it is also referenced later in the rules, again referring to written instrument, but written instrument is not defined in the Ohio Rule of Civil Procedure. Regardless of what it is that you're attaching, the written instrument must still be authenticated. And that's the key step to avoid a potential pitfall of having something thrown out. You should attach it, thinking that this contract, this promissory note, what have you, is properly attached, but if it is not authenticated, it may not get the job done.
Yeah, can we stress that? If in doubt, attach an affidavit, just do it. Just please go above and beyond, because then we're stuck with what do we do with this? So.
But you don't want to get bounced out because you didn't file the affidavit. All right. What written instruments are not? A police report is not a written instrument. Court documents from a previous case are not technically a written instrument, but we're going to see here in a little bit that there may be some wiggle room on that point.
So jurisdictional issues. This one it's a little sneaky, right? It's not actually a 12B6 or a 12C issue. It's, if someone's gonna challenge jurisdiction, it's through 12B1. But a lot of times these challenges are raised together in the same motion, so it can be a little tricky to tease out. But this distinction between the two is important because courts are allowed to look outside the pleadings to determine whether they have jurisdiction. So it's just something to be aware of as you practice or are considering these types of motions.
Res judicata issues. So you get a complaint comes across your desk and you look at it and you said, my God, this has already been resolved. You took care of this in this previous case a year ago. What do you do? Well, again, it depends. If you file an answer, if you're a defendant, you file an answer and you attach a certified copy of the court docket in the prior case you believe gives rise to res judicata, that may constitute a written instrument and may allow you to prevail on a motion on the pleadings. However, that's not 100% certain. So earlier last year, in February of last year, the court looked at a res judicata issue and accepted a certified copy of the court docket and ruled on a 12C motion. However, 6 months later, again last year, the court looked at the certified copy of a docket in a malpractice case and found that that did not meet the bar for a written instrument and therefore did not consider it in the 12C motion.
And I would just add on that, it was a statute of limitations issue in the legal malpractice, and they were trying to establish it was outside the statute of limitations. So we had to take, some may argue you could take judicial notice of a date of the filing. I think that was not the holding.
So you have, it really does depend on the specific facts of the case and whether or not you can establish res judicata cleanly on the record, the prior court record, or whether the plaintiff might have a claim, well, that claim was in a compulsory counterclaim, or wasn't compulsory to bring that claim, and therefore it's not truly res judicata, in which you'd have to, in which case you'd have to go to facts and documents outside of the court document, which would probably then bring it outside the bounds of a proper 12C motion. So it really depends on the specific facts of the case, the details of the case, the statute of limitations that might be relevant. So there's no, I can't give you a clean black letter law on that particular question. But it is out there, and depending on the facts, some courts have accepted it, other courts have not, again, depending on those specific facts.
Can I make one other note? I don't know if you have statute of limitations coming up. Because this is something I didn't really appreciate as a practitioner. We're stuck with the 4 corners of the complaint. And if it's a statute of limitations issue and it's not pled that it's within the statute or outside the statute, then we've had motions to dismiss filed trying to show it's outside the statute of limitations, but the 4 corners of the complaint pled it's inside. Well, we're kind of stuck with that. And then now you're under summary judgment. So be aware if you're the plaintiff. I mean, you don't have to plead it's within the statute of limitations. If you're a defense, you're gonna have to think long and hard how you're gonna show that's outside the statute of limitations properly in a 12B or 12C.
And often those kind of issues, if the dates, the relevant dates for when the bad act allegedly happened are not in the complaint, then you're probably stuck with filing a Rule 56 motion as opposed to a Rule 12 motion. But remember, that doesn't doom you to prolonging the case unnecessarily. You can bring up Rule 56 motion at any time if the facts of that particular case warrant it.
Then the last issue we want to go over, Judge Sheehan hinted at it a little bit, is judicial notice. And it's a little bit unclear whether courts can take judicial notice at 12B6 or 12C stage.
We don't like to. Let's put it that way. We don't like to.
Right. So obviously the general rule is courts can take judicial notice of their own dockets, but not the dockets in other cases. But there seems to be some surface level inconsistencies in the cases and how that's actually applied on a motion to dismiss stage. So a great example of this is Edwards versus Kelly. This is the legal malpractice case that Alex was referring to, and the majority held that they could not take judicial notice of the prior criminal case or certain journal entries in that case that would have been dispositive on the motion to dismiss issue. and cited a lot of authority and support for that. And then the dissent would have taken judicial notice and cited a lot of authority in support of that too. So the takeaway here is to just be careful and be cautious and maybe consider a summary judgment motion instead of a motion to dismiss when the court would have to take judicial notice of something.
Okay, I think we have like 2 minutes on this segment, right, Bridget?
Yes.
So does anyone have any questions? Because we got 2 more good hot topics too. Okay, well, if there's no other questions, thank you very much.
Thank you. My next presenter. I'm gonna sit over here so we can feel all alone. Next, we have Tony Petruzzi. We're gonna talk, by show of hands, how many people know last year, the Ohio Civil Procedure Rule 37E was completed? I know we're all in COVID land, but, I'll put you over. But the rule completely adopted the federal rule 37E. 37E dealing with electronically stored information, what happens when it's spoiled, when it's destroyed, and sanctions courts can impose. But it's a really big deal. I know when I was in practice, electronically stored information was like, sometimes the case just didn't warrant getting involved in it. It was a small case, the party, the lawyers agreed not to deal with it. But I think we're going to see a lot more of it, and because of this rule, the courts have some very specific options to sanction. So you need to know what needs to be done and how you can avoid being sanctioned yourself. So Tony Petruzzi is a local expert, I'd like to say, on this. Partner in Tucker Ellis, civil litigator, business, as well as all the way to white collar crime and everything in between. But he's also in charge of the firm's e-discovery program, and he's on the working, I'm going to get this wrong, the working committee for the Sedona Conference, which, if you don't know the Sedona Conference, that's a national organization that researches, writes white papers, and really focuses on electronically stored information discovery and these issues. And they're cited quite a bit in federal case law. So to be on a national level, you're kind of a local expert hero. And this is what, your 3rd presentation in 2 weeks?
Third this week, third this month.
Yeah.
Every Friday I've done a presentation apparently, and then next month we have our annual meeting for Sedona Conference. So unfortunately for the firm, I haven't been doing much work.
Well, please help me on.
All right, well, thank you very much. Can everyone hear me?
Yes.
Do I get to play?
Well, I wasn't at the rehearsal,
Okay.
so
Sorry.
we'll have to see what we can do that.
Okay.
All right, well, thank you very much and good morning, everybody. It's definitely an honor to be here, and it's definitely an honor to be here with Judge Sheehan. As she had mentioned, Ohio Civil Rule 37 was amended on July 1st of 2021. And what it did is it tracks the federal rule now, 37E. We've had some amendments to multiple rules lately. 26B1 was amended in 2020 relating to proportionality to mimic the federal rule. And then recently we have the addition of evidence rule 502, which we did not have previously in Ohio, which tracked the federal rule. So we're seeing a lot of changes in terms of that. And so what's good about that is, since this is so new, we're able to look at federal cases to kind of see, how courts are handling these different things like we have here with 37E. Now, in 37E, what we're doing is you look for what the culpability was and then determine what are the appropriate sanctions. And for that, what you do is there's a couple different, scenarios and types of sanctions you have. In 37E, you have to see, was there a duty to preserve data? Was that data lost? Was that data lost because of a party's failure to preserve it? And can that data, and this is ESI, can it be replaced or somehow obtained through additional discovery? So if that's the case here, and if you look at it, then you can get to sanction. And there's essentially two types, two versions. There's E1, which you see here on the screen, And basically, it's the prejudice. If you find prejudice, but you're not looking at intent to deprive here, just prejudice on the party, regardless of how it occurred, then a court can issue measures no greater than necessary to cure that issue. And so again, these are all in a sense sanctions, but sometimes you will hear under E1 is curative measure, not so much sanctions, although it technically is.
To drive the point home, because then we'll talk about it a lot, but you may say, they destroy data, haha, I get sanctioned. But that's not necessarily the case. You still gotta show they were prejudiced at a, well, not at a minimum. Under E1, you have to show that it wasn't just like you deleted my Ring doorbell and I don't really need that, I'm gonna get sanctioned. That has to be relevant and prejudice has to occur.
Right, exactly. And so that's a good thing. If you have a case like that, and you feel like the elements weren't properly found, that's when you take it up to the appellate court. So first we have E1, which is prejudice, and then we get to E2. E2 is intent to deprive. And what is intent to deprive? That is where, you're going to look to determine whether there was, really bad faith in doing it. And if there was a reason, they actually deleted the information. And if that's the case, you're going to get harsher sanctions. And the sanctions that we could see here is that a court can presume that the information was unfavorable to the party. The court can also instruct the jury that it either may or must presume that it was unfavorable to the party. And we'll talk about what scenario in a minute. And then you can also have dismissal or a default of a case if the sanctions are severe enough. And so you do see that in some cases, and sometimes you don't. That's a very, very harsh sanction. We had something recently, it was on the news last year related to the opioid litigations. There was a case in Tennessee where the court felt that the sanctions were so severe, or the e-discovery issues were so severe that they actually issued a default judgment and a $1 billion judgment against the pharmaceutical company. That it's since been reversed, I think, based because there was a motion to recuse the judge pending. But that's where you could see, significant problems if you make sure if your client's not taking care of data. So next is.
So reiterate, I just don't think you can say it enough. There's 4 requirements and you have to meet each one of those in order to get your sanction. So it's easy to be, like I said, oh, they deleted the data, but that's not good enough. So go ahead. I jumped in.
Okay, so yeah, exactly. So you have 4 questions that have to be asked before you can even get to sanctions. And all 4 of these must be proven. If any of them cannot be proven, you're not even going to get to the sanction part. So that's another thing to look at in terms of whether you have a case and whether to bring that, a decision that you did not like up on appeal. And the first one, as you see, is was there, in terms of relevant ESI, should it have been preserved in anticipation and litigation? And we all know what that is. You do preservation, legal hold, that sort of thing. So first of it, was this data that should have been preserved? Because that also goes into proportionality, because not only is there proportionality in discovery, there's proportionality in preservation. So should it,
before the complaint is even filed.
right, exactly. Before the complaint, if you're put on notice, which we'll talk about a case in a second where that was a scenario, put on notice that you should have preserved it and you didn't. If the answer is you should have and you did not, and it's yes, then you can move on to the next question. If it's no, then you don't have to even go to the other questions because you cannot get sanctioned. So
Before we move on, though, we talked a little bit about this. Is it the lawyer's obligation to send out a preservation letter? If you don't want a preservation letter, it's tell your client, make sure you preserve all your electronically stored information. Can the lawyer get in trouble if they don't do that?
yeah, it's not fully developed. A lawyer can be sanctioned for failure to do that. I can tell you there are cases where they did and did not get sanctioned. So, it is a best practice. There was a case recently where it said, it didn't sanction the attorney to chastise the attorney for not sending out a legal hold, but stated that ultimately it is on the party to preserve the data, regardless of whether the attorney did it or not. And that case was based upon case called Paisley Park, which is, if anyone recognizes that name, and you don't have to raise your hand, it relates to Prince. And after he passed away, there was a loss of some data, and the court basically did not sanction the attorney, but stated that, the duty is on the party to actually preserve the data.
What about the plaintiff too? If it's a plaintiff and they have a cell phone and they have pets, are they out? Like if you're a plaintiff's lawyer, should you also tell your plaintiff, your client?
Oh, absolutely. It's, you have to preserve the data. If you're, especially if you're gonna bring litigation, it's really gonna be a high standard looked upon you. You want to bring it, but yet you didn't preserve any of the data. Because you think you're a single plaintiff, and then maybe you're up against this big company and they're the ones that have all the discovery. You can't lose sight that you have to make sure that you preserve certain things. And in the world of e-discovery, more and more things are being sought after. And it's not just text messages, it's instant messages, it's WeChat, it's anything, messaging on your phone. And so that has to be considered, that if you're gonna bring a litigation, make sure that your party, that your client, can comply with everything if you want the other party to comply as well. So that would be important.
Okay, what does it mean to be lost?
So loss is pretty simple. It's you don't have the data anymore. So that is the second question. If the data is lost, then you can go to the next question. If it's not lost, then it's you're not going to have sanctions. So generally, it's pretty straightforward. You're going to bring a motion if the data was lost, and if it wasn't, you won't bring a motion.
Well, it was deleted, but it's back up. Is it lost?
Well, it's not lost. That would be the fourth question.
Okay.
And
Let's go back to the.
you're in charge. You're the judge now. All right. So basically, and this kind of goes to the question about preservation. So it was lost, but wasn't lost because of the party's failure to preserve the evidence. And again, the yes or no question. And maybe there wasn't a failure to preserve, or not failure to preserve, but reasonable steps taken to preserve something. You'll see cases where, okay, so they put a litigation hold on something, and a phone, for instance. And then there actually is a case out there where the phone, unfortunately, which had very relevant information on it, was stolen. Now, I have doubts as to whether it was stolen, but the court did say, well, the plaintiff did, file an insurance claim, so there's evidence that it was stolen, and so there were no sanctions for that type of lost data or for failure to preserve. That was a failure to preserve case. And so you do have scenarios where, maybe someone, it was lost, but it wasn't. They took reasonable steps. It wasn't foreseeable that the phone would be lost if you were to believe that the phone was lost or stolen. So that's a scenario where you could have a no, and then you don't go to sanctions on it. And there wasn't sanctions on that case. And I remember that one was it was a GoDaddy case. It was a wrongful termination case. And so then you go to the fourth question. Can it be restored or replaced? And being restored or replaced, as the judge said, maybe it's backed up. So if it's backed up, it's going to be, you can restore it. If it's emails, and say you deleted one email account, but hey, those emails are also in this individual's account. Well, again, it might be a question of fact, but you can argue that, that is restored in a sense or replaced. You can get other scenarios where a case we'll talk about briefly today, where you have data, and that was data that you could utilize for a certain element of the case, for damages, for the opposing party. This would have been able to help them establish their damages, but you lost it, you deleted it. So then the question is, okay, do you have other data? And in one case, we could talk about, yes, there was replacement data. It wasn't the same data, because that data is gone, but it was a different type of data. And the court held that that data could be used for the same purpose. Therefore, it was replaced. Therefore, you don't go to sanction.
This seems to be a hotbed of argument. Like there's always going to be an argument, whether it's replaced. The plaintiff might say, well, I took a photo of that text, and so I have the text. And then the other side will say, but I don't have the metadata of that text. I mean, it's going to be perpetually.
Yeah, no, absolutely. That's important. I don't know if Alex is still here, but he had, well, not him, but his firm had a famous case out of Southern District of New York, where it was a fraudulent text. It wasn't a real text. And it was the individual took a photo of their old phone because they couldn't screenshot it because that phone was broken. Turned it over as a PDF. They're like, oh, well, we want to see the metadata, of that picture. And so they sent the picture over. There was no metadata showing that an iPhone X took a picture of an iPhone 5. And unfortunately, both of those phones were broken. And so they weren't able to access them. And I know Alex's firm Littler, New York, they hired an expert and actually proved that it wasn't even an actual text message. They looked at the font, they looked at the emoji, they looked at the picture of the battery icon, and they said these did not exist on an iPhone 5 or iPhone X. Therefore, it was just completely altered evidence. So, yeah.
I like when they go to get the phone repaired at Verizon and the tech accidentally cleans the whole phone.
Right.
And better yet, the lawyer goes, it's okay to go to Verizon and get your phone fixed. You shouldn't do that either.
Yeah, no, that happens.
So if you go all four of these, what do you get?
Well, now you can go to sanction on whether it was prejudice or whether there was an intent to deprive. And prejudice, again, is pretty simple. Was it prejudice to the party who could have benefited from the data? And if so, again, they're going to have measures, that can kind of be curative in nature and fix it. But the bigger one is intent to deprive. And that's what people are going to look for there. And so the question is, what is intent to deprive? Now, in this one, you don't have to actually show prejudice like you do for E1. So we're going to talk about E1 versus E2. You don't have to show prejudice. It's going to be presumed. But, we're looking at bad faith, and we're going to look at intent or intentional destruction of data for intent to deprive. It is not going to include negligence or gross negligence, unfortunately, for those of you who want to go after someone. And one of the main reasons of it is that you could negligently delete, or your client can negligently delete their data, and that data actually has been, useful for them or helpful for them. So that's why, negligence isn't there. And the new rule really does split it up between, prejudice and intent to deprive. So it's going to be bad faith. And a good way to kind of explain and show the difference is showing what are examples of prejudice versus an intent to deprive. And for prejudice, you might see an example would be you failed to turn off the auto delete, such as on your cell phone text messages. You always want to tell your client, turn that off, because a lot of people have it deleting automatically in 30 days. Same with email systems. A lot of companies have email systems set up for auto delete, so you want them to turn that off. But if for some reason they just didn't, even though it was on litigation hold, if there wasn't that intent to just make sure you got rid of the data so the other party doesn't get it, you're going to see a curative measure. That's going to be prejudice. Also, things like, you have a 1-year retention policy, but you started deleting all your stuff in 6 months. Well, unless there's some evidence that you did it on purpose, so the other side couldn't get it, you're going to see just only prejudice there. You'll also see like a failure or delay in issuing a litigation hold, either by counsel or by the company, because a lot of companies do that themselves. Also, you can do litigation holds on certain devices, and like we talked about, the cell phone and emails. So that might be just something that's prejudice as opposed to intent to deprive.
Unfortunately, it seems like we just have to learn from case law and other people's mistakes on a lot of this, which again, go back to federal law, because really the federal rule has only been around 7 years.
Yeah, it was 2015.
So there's not a ton, and everything's really district court decisions or magistrate decisions. So there's not, I think there's 2 cases out of the Sixth Circuit. There's not a lot.
Not many cases at all. So yeah, very small in terms of Sixth Circuit, but that's why we look to all around for federal and see what kind of cases are coming up, just to see how different things are handled. And all courts decide things differently, as you all know. Burden is one of them. Who has the burden? Usually on motions to compel and whatnot, the moving party has a burden. But in this instance, burden is not placed on an individual party, one party or the other, under this rule. And the court has discretion to determine who the burden is going to be put on. And what you will see sometimes is, and the committee notes stated to the federal rule, is that sometimes it might be unfair to put it on the party, the moving party. So what I've seen in the case law is definitely the courts go different ways depending on what it is, but maybe the different element, it will determine which party has the burden. For example, is there anything in existence that is relevant? Well, it might be unfair for the moving party because they didn't see the data. They don't know whether it existed or whether it's relevant. And the case will reference really quick about video cameras, the movement doesn't know whether there was video on there because they just have it.
I appreciate the employer who had a video camera and supposedly there was a fight and they said, well, plaintiff's got to prove that we did have it. But they were the ones who controlled the camera.
Right, exactly. And they control the camera.
We didn't buy that one.
Yeah, no, we didn't buy that one. And so they said, you know what, the burden's gonna be on the other party because they had the ability to do that. So you will see the burden, different. And then who decides it? The judge usually decides what it's going to be, whether there's intent to deprive, but in certain circumstances, the judge may have the jury decide whether there's intent to deprive and then let them know. If you find an intent to deprive, then you may use that and say that it was unfavorable to the party who lost the data. So you may take that into consideration.
Do you think that happens more than not in really egregious cases? Like, I'm really surprised that the judge has the option. The judge can decide intent to deprive or give it to the jury with a jury instruction and let the jury. So now the jury is going to hear all the facts and determine whether that party had an intent to deprive and delete this.
Right, and it's something you don't want, but that is a measure. It can be considered a curative measure if you find prejudice. Okay, I find prejudice. I'm going to now send it to the jury to find intent for a much harsher sanction. So that's what you'll see in these cases.
But I would say, oh God, there's a question.
Well, at what point are you getting into what a spoliation claim is, right? Because
Right.
I feel like you get a jury once you rise to the level of spoliation. And, what's the difference really between 37E and a spoliation claim under the common law?
All right, well, you have 37E, it is spoliation, but it's under a rule. And now what you normally see in terms of spoliation, you'll see the rule 37 is actually related to e-discovery or ESI. Not documents. You're going to see documents come under common law.
You could still
That's
have
more
e-discovery. You could still have a spoliation claim of electronic documents that were intentionally destroyed, right? So you could insist on a jury, if say you have a judge that doesn't want to give you a jury. I personally like to have a jury when I can, most of the time. And so, I have a judge that, I say this actually is beyond just Civil Rule 37E. This should be a spoliation claim that goes to the jury. What's the difference?
The difference is, and I think what you're seeing now with 37E, they're trying to do a push to have some kind of structure in terms of sanctions when it comes to electronic discovery. So this is similar. We had a 37E prior to this, and it is very similar to it, but now it gives structure. And the reason why the federal rule changed in 2015 was to give structure to the spoliation of e-discovery and to give, to kind of point out to the fact that you have prejudice and you have intent to deprive and what a judge can do there in terms of versus just a common law spoliation, because you're mostly now seeing it under 37E, whereas you're seeing just regular documents under the spoliation.
And I don't think this is right. During the case, the spoliation occurs, which is you're filing a spoliation claim after, like that's your whole claim primarily, but
Yeah.
so it gives, and then you have to be careful. Do you file your motion under 37E1 or 2 or both? I don't know.
There's a lot of overlap. It's
There's a
really,
lot.
and when do you file it? Do you get it in the same case?
Right.
Does that prejudice?
And sometimes they'll wait till after it's filed for motions and then there's a lot of things to still bubble up on this. We just want to hit a couple highlight practitioner points. It seems the theme in these cases, if you're the attorney, do everything you can do and you're less likely to be sanctioned. So one of the cases that Tony had touched on, we've all seen this where you do as a lawyer everything you can do. Here's my litigation hold, I gather all my documents, I told all my client, and there's always that one employee who opens up the drawer right before deposition and goes, well, did you want this? And only in this case, he had it all stored at home on a hard drive, then he transferred to a thumb drive, and then he transferred to another drive, and then he cleaned his computer. I don't know why people feel that they need to clean their computer, but it happens. And that happened in a case, and the court said, okay, you know what? The employer was very forthcoming. As soon as they learned, they produced it. The employee said, yeah, my employer didn't know I had this. The employer tried to do everything right and ultimately was not sanctioned. But those scenarios come up versus the employee you mentioned with the plaintiff's case, where the attorney didn't really research what the plaintiff was giving him as far as here it's a harassment claim, and here's the text that proves the whole case. And ultimately, it's proven that text was fraudulently created, and the attorney got sanctioned in that one for not doing more diligence and making sure that it was legitimate. Did I summarize those correctly?
I think the first case is metadata versus Vita System. That was out of Southern District of New York, September of 2021. And that was a case where the kind of what we just referenced is it looks like it was brought under E2, intent to deprive, but not E1. And the court did not discuss E1 at all. And again, they just completely lost data. And it was, I guess, an accident. But they went for, intent to deprive, and therefore didn't even look for prejudice. And there probably could have been prejudice there. In terms of the one we talked about, the text message, that's Rosbeck versus Montefiore, Southern District of New York, August 2021, fraudulent text message. And the attorney just really didn't, basically didn't instruct the individual to preserve the data and allowed this, in a sense, charade to go forward because of their failure to do that. And then the last one we mentioned, we kind of referenced a video tape earlier. That one is it's Hollis versus Siva Logistics. And that is a case where they actually sent it to the jury instead of the judge deciding on the intent to deprive. And I just had a couple quotes from it. The court basically said, look, I think it probably is an intent to deprive here, but a competent attorney can argue that their client was incompetent as opposed to intentional. And they said, humans are just as likely to be dim-witted as they are dastardly. So in that it's sent it to the jury to decide whether there was an intent to deprive.
So our time is up, but I would say here, I have a lot of these questions, not only look to federal law for guidance, but those the Sedona Conference put out to the public, the practitioners, documents.
Yeah, you'll see there's a Sedona Conference. They do things called commentaries in addition to their Sedona principles, where if you have a question on e-discovery and including spoliation, Rule 37, Tom Allman, he's from Cincinnati. He has publications on the Sedona Conference website, which talks about all that and does the difference between 37 and spoliation and all that. Gigantic ones. And then we also have secret ones that haven't come out yet, but expect to see one hopefully soon related to 37, an updated one. So.
Well, thanks. So the last hot topic is en banc. I've never filed a motion for en banc. Has anyone here filed a motion for en banc? Like more and more en bancs getting filed all the time. So we thought, maybe we'll talk about this because why all of a sudden are we filing? There's this increase in en bancs.
Excuse me, Judge Sheehan.
Yeah.
We're getting some feedback from the online participants that they're not able to hear the speakers. So if everybody could make sure to lean in and speak loudly and clearly into the microphone, that would help. Thank you.
Thank you. Is that better? Okay, I probably was too far away from the microphone. So en banc. For those that don't know, I mean, Jim's gonna cover it, but I don't even know where to begin with this title. When you ask 12 people where they would like to go to dinner, all the judges, if there's two opinions in conflict, then all 12 of us will review that legal issue. But Jim has the unfortunate job of being our en banc lawyer. So that means not only Jim was a judicial attorney both in common pleas and the Court of Appeals, and then willingly took this job as en banc lawyer. All he does is review the motion for en banc. Jim is also a certified appellate specialist that Judge Boyle had mentioned, and he's also a graduate of the Ohio State Law School. So please help me welcome Jim McNeil.
Thanks so much. As Judge Sheehan said, I am the 8th District's en banc staff attorney. So a huge chunk of my work entails basically facilitating conflict resolution. And the reason why I exist is that we have
like you more than
yeah. We have a very diverse court and a large court with 12 judges. And they have backgrounds from all over the legal spectrum. We have formal prosecutors, partners from civil law firms,
trial judges with decades of experience, former magistrates. We even have a former nurse. So we have a lot of different perspectives that go into our decisions. And so conflicts in the way that we view the law inevitably bubble up occasionally. And the en banc process is the way that we resolve those. And en banc really boils down to promoting consistency in the law that you get out of our court. And so the purpose of the whole process is to iron out instances where perhaps we're not being consistent with a past decision, even if it's from decades ago, and we simply need to clarify that it's no longer controlling law. The en banc process exists to remove that ambiguity so that practitioners, parties, and trial judges know what the rules are for the law as they're trying to apply it below, and they're not confused by perceived differences from our court. Our court takes it very seriously. Other courts have, I think each court in Ohio does it a little bit differently. Most of the courts are smaller than ours, so their process is a little bit more simplified. But with our court, all 12 judges will look at these en banc applications. They'll get a detailed memo from me analyzing whether or not there is, or at least I perceive there to be a conflict in the law that's being raised, and then they'll take a hard look at it and decide whether to proceed and potentially resolve the conflict. And then, if it does, if in a rare instance where we do acknowledge that there is indeed a conflict, our process for resolving it is quite time consuming. That the judges really put a lot of work into a full en banc opinion and straightening out the law. And you'll get in those in the rare instance where we do send out an en banc opinion, you'll see the judges will develop them in great detail and explain the different positions and even the side that might not come out as controlling in the end, they'll still have an opportunity to say why they think the law should be otherwise. So these opinions are very big in depth. But from the practitioner's perspective, we can get into what an en banc is exactly and what it's not. And it's probably easier to define it as what it's not, because they're fairly rare to have a legitimate en banc conflict. It's not an opportunity to re-argue your case. And that's sort of the biggest thing I see on failed en banc filings. It's just a party will use it as a Hail Mary and essentially re-argue things that have already been addressed by the panel, even instances where they simply think that, hey, I think this Ohio Supreme Court decision means that I should win this case, and you didn't rule the way I wanted to, so I think this is a conflict in some sense, but that's not a conflict.
Do you think practitioners are saying, well, this panel got it wrong, but if I get it in front of all 12, they're going to get it right?
Right. Yeah, that certainly is. But in the
Do we have that authority to overrule another panel?
no, and not certainly not in the en banc process. It's not designed for that. It's designed for a one-to-one conflict resolution where a prior panel addressed either the same exact black letter law and said the law is XYZ, and a new panel says no, it's ABC, and we have to hit that head on. But those ones are fairly rare. The more common instances of an actually successful en banc is where the court agrees on what the black letter law is, but when they're applying it to nearly identical facts, they come out differently. And that's when we have to really sit down and see the nuance and how our judges look at the law and how it should be applied.
See that very often?
More often than the black letter law conflicts, yes. But still, it is a rarity. I was funny enough, I was looking at our numbers yesterday, and I think that amongst all the en banc filings we have, which often approach 60 a year, only about between 1 and 4 a year are legitimate en banc conflicts that we accept and we resolve. So over 95% of the en banc filings we reject because either the party has filed something that is frankly frivolous, or the parties are arguing that dicta is in conflict, or some other variety of issues. But yeah, it's when you do have a legitimate conflict, it sort of jumps out and hits you in the face because you can tell practitioners or trial judges will be confused on what the state of the law is.
Well, can you touch on, because motions for reconsideration and motions for en banc are filed at the same time, right?
Yeah, and that's they are supposed to. You have a 10-day window when your case is when our court sends out its decision. You have 10 days to file your appellate rule 26 motions. And recon and en banc are the two main ones where you can ask the panel for reconsideration if you feel that they have misapplied controlling law, made an obvious error. En banc is a much smaller subset. Recons are more common. En banc is strictly limited to claiming that a prior 8th district case basically got the law the complete opposite, and that we need to resolve that conflict.
Before we move on from can you touch a little bit about the paths? So it's in one motion, a motion for recon and a motion for en banc, but do they take different paths and how they're going to get resolved?
Oh, absolutely. The motion for reconsideration can commonly be resolved by the panel fairly quickly. It's just the 3 judges on the panel. They'll look at the argument that they've completely missed something and that they need to change course on recon. And they can deny it fairly promptly if they want. That can be handled in a matter of weeks or so.
It's not held in abeyance until the en bancs resolved.
Occasionally it can. That's a discussion amongst our court as to how our judges like to do it. I like to encourage them to hold off on ruling on motions for reconsideration when there is a pending en banc in the same case, because it allows our court an opportunity to issue a reconsidered opinion that might moot an en banc. A lot of times we'll get conflicts that are arguably unnecessary, where we went down one path and potentially put ourselves into a conflict bind. But if we had just chosen an equally applicable path, we could avoid the conflict. I saw there was a question in the back by Judge Forbes.
We actually ran out of time in our presentation, so I'm gonna take a smidgen of yours. What is the different tests that you apply? Like, what do we look for on the appropriate way to resolve a reconsidered motion? Can people fix a trial or a court of appeals opinion that they don't like by asking for reconsideration? Will you restate the question?
Sure. So Judge Forbes was asking sort of what the appropriate standard is for a motion for reconsideration. And there actually is a black letter law definition that I'm sure I'm going to mangle off the top of my head, but it has to be an obvious error in the panel opinions analysis. For instance, a controlling Supreme Court decision that the panel did not apply, or other controlling precedent that they clearly have missed or run afoul of.
Anyone been successful having a motion for reconsideration granted? It happens.
They do happen. We issue far more motions for reconsideration than we do en bancs. And in fact, many times we'll get an en banc filing and I'll look at it and say, hey, we do have a conflict here, but it's a completely unnecessary conflict. We can even keep the same outcome on this case and simply issue a reconsidered opinion, but go down an equally applicable pathway that gets you to the same outcome. So it's kind of, the conflict might be irrelevant in that instance, but in order just to keep clarity for the law, it's still a good practice to issue the reconsidered opinion so that future readers and trial judges aren't confused by our court saying different things. So the recon is a very, very important tool that sort of coexists alongside en banc.
I didn't mean to get you off track.
Oh, you're
So
fine.
back to filing a successful en banc.
Let's see, where are we at?
It's impossible to read from here.
Yeah, right. So the most important thing when you're filing it is to take a hard look at both Appellate Rule 26 and Local Rule 26. And the biggest component, and one that we see that gets you kicked out administratively without a thorough analysis, is the first one here. You really need to give us a concise description of what the conflict is. If I read your motion and it is meandering and I can't tell what exactly you're arguing as to conflict in the law between various decisions of our court, then that's a quick way for the motion to simply be summarily denied. You have to also provide citations. So tell us exactly where in the relevant opinions, the current opinion and the prior cases, tell us exactly what paragraphs are in conflict and how they're in conflict. You also need to explain why this is relevant to this case, why we need to resolve this conflict. If it's just a conflict that stems from dicta or it has no bearing on the outcome of the case, that's not going to get you an en banc opinion.
And it's important that it could be administratively dismissed before
Right.
it goes anywhere.
If you don't comply with the rule, and it is jurisdictional, that 10-day window to get in your motions for recon and en banc is a very hard deadline with a very tiny exception for extraordinary circumstances, basically. And if you don't read the rule and comply with it, you're going to miss your bite at the apple for both recon and en banc. Not that en banc should be filed nearly as often as recons. You don't want to equate the two. En bancs are a much smaller segment that should only be used when there is a one-to-one conflict with prior 8th district decisions.
And I know you're going to talk a little bit about a few of our recent en bancs, but before, can you pull the curtain back a little bit and tell them a little bit procedurally how we handle these motions for en banc and the process so that they know when they're writing it, where is this motion going and how is it being handled?
Sure. So when they come in the door on day one, I'll immediately take a look to see if it complies with the rules. There are numerous instances where a case will be administratively dismissed by the administrative judge for failure to simply comply with local rule 26 and tell us what the conflict is, give us some citations. We get numerous filings, very rarely by attorneys, but more often by pro se litigants that don't even give us an 8th district case. Or you file your en banc motion and your alleged conflict is between your current decision and the Supreme Court decision. That's just not an en banc. It's not the purpose of en banc.
If it's administratively dismissed, is there a way to fix it or is it done?
No, it's pretty much done. In rare instances, de minimis non-compliance with the rule will allow the AJ an opportunity to let you correct it. For instance, if you under the rule, you're supposed to file your recon and en banc jointly. If you're going to file both, you can't. If you're going to file an en banc with a recon, you have to do it in one 10-page motion. So we will often allow parties who file that separately a chance to file a corrected motion, but nothing is going to save you from the 10-day period. If you don't get your motion in on time, it's going to be administratively dismissed. In fact, we have to. We just don't have jurisdiction at that point.
And that's not circulated amongst all 12 judges so much as it's between the AJ takes a look and determines, right?
Yes. So that's still in sort of the administrative process. I'll flag a motion that just simply doesn't comply with the rules. It's not an actual en banc motion worthy of the 12 judges reviewing it. And we will, in appropriate situations, it'll just be administratively dismissed. But assuming it gets past that sort of screening phase, then I will take a hard look at the alleged conflict, and I'll provide our judges with a memo sort of giving them a neutral, objective analysis as to whether or not I think this is a conflict, whether or not I think the Supreme Court will view this as a conflict, because, you know, if we don't, we are duty bound under their decisions to resolve our conflicts. And if we don't, then we're shirking our duty. And so I will tell our judges honestly when I think that maybe they've created a conflict, even when perhaps they don't want to hear it. That's sort of.
So what kind of time frame can a practitioner expect that to take place from the filing of the motion en banc until you circulate a memo to the judges?
Under the best of circumstances, it should be between 2 and 3 months, depending on how many cases we have had filed on any given year, or if we have a really large decision like some of the ones I'm about to highlight. It can take longer. It can take up to 6 months or so. And in the rare instance where you do hit on an actual conflict on a substantial area of law, it can take a significant amount of time because of the back and forth with our judges in resolving the conflict and drafting an en banc opinion.
Those were all my questions.
No worries. So we have 3 en banc decisions from the last 3 years, I think, that are worth highlighting. The first one is probably the biggest en banc decision that we've done in about 4 or 5 years now, and that was State versus Del Valle. And if you're a criminal practitioner, you've probably encountered this case by now. And it dealt with the constitutionality of the Reagan-Tokes Act. And this is actually the rare example of a black letter law conflict where this is not a panel is stating the same law as the prior panel, but they're applying it the same facts differently. This is straight up whether or not a statute is constitutional. And part of some of our judges believe that it was, and some of our judges believe it was not. And so we recognize this from the inception. And I don't think anyone was surprised. Reagan-Tokes was a long time in the making, and we from the very first few cases, I suspected we might have a break in how judges would view these constitutionality questions, which were very substantial.
By the way, not all appellate districts have determined in their district if it's constitutional or not. I know it's pending in the Supreme Court.
It is. This is still an issue, and Reagan-Tokes, I think, went into effect over 2 years ago now, and we're still at a place where we're waiting to hear from the Supreme Court on whether or not the final answer on constitutionality. I do think that.
Wally's been released from jail, but
Yeah, he might be out already. It has taken a long time, and that is sort of an important thing to highlight here. When you have a conflict like this, that it is a conflict on black letter law and substantial issues, resolving it takes a long time. It's very time consuming. In this instance, we knew immediately when we had a conflicting decision from a panel before we even released the case, we knew that we were going to have a conflict on this. We have a couple tools for situations like that. We can hold off on releasing a potentially conflicting decision and try to resolve the case internally, or we can release the case and immediately acknowledge that we have a conflict and let the parties know. In this instance, I think the benefits of releasing the conflicting decision were very helpful. This is the only case I'm aware of where we let the defense bar and the prosecutors come in and raise oral arguments on en banc about whether or not which side of the constitutionality coin they felt was correct. So this was as thorough an en banc as you can get.
which, by the way, another procedural note. When we've agreed to take an en banc, there's no order that says we're going to take it, right? We just hold it, and then there's no order. That's the first oral argument on an en banc I'm aware of.
It is. This one was a sua sponte en banc, so we didn't wait for the parties to tell us, hey, what are you doing? You just issued conflicting. We acknowledged it from the get-go that hey, we know that there's a split of authority in our court as to how to resolve this important constitutionality question. In a case that does not get sua sponte treatment, a party will file a motion, and if it is a successful en banc, they might not see the result or hear anything from our court for a good amount of time before suddenly we issue an en banc opinion that says, yes, we acknowledge there's a conflict and here's the fix to it.
No news is good news.
Yeah, so no news is good news. In fact, and again, the process is very time consuming. I think Reagan-Tokes took somewhere between 6 and 7 months to fully resolve. And the phrase iron sharpens iron really does come into play here. You know, our judges, at one point, I think we had 6 judges that were considering writing on this case. I think we ended up with 4. And the exchange of the various drafts between the writing judges made each draft stronger as the judges considered, the other side's view of things, good points raised by someone on the other end of the question, and they would address, each other's issues. And so, internally it can be a stressful process, but it actually results in very, very high quality work. So the process might not be super fun, but it is good for the law.
But if it's denied, you don't always get an opinion saying why it's denied, right?
If in a lot of instances, my test on this one's actually pretty simple. If the motion and an average practitioner could look at the case and immediately know why we've denied an en banc motion. We will issue a rather plain vanilla denial entry without any decent explanation. If it's an instance where I think there's some confusion that could arise, or it's a close call, and I think the Supreme Court might not understand why we've denied something just looking at it on its face, we'll provide a brief but detailed explanation as to why, this is not being accepted for review.
We have a couple of minutes left. Is there one?
Question, can you discuss the sua sponte en banc, please? And
Sure.
how it happens and how our court processes it?
Sure. So Judge Boyle asked about the process for sua sponte en bancs. We have two different tracks actually on that. Del Valle illustrates one of those where our judges proceed to publish a decision that is in conflict with a prior black letter law decision. In Del Valle, it was yes or no, is this statute constitutional? And we will in a sua sponte en banc like that, will almost immediately, we have 10 days in order to issue an entry alerting the Supreme Court that we know we have a conflict, that this case is going to stay with our court through the resolution of that. The 45-day period to appeal to the Ohio Supreme Court doesn't run until we resolve our en banc. So as long as we issue a sua sponte en banc entry within 10 days, we retain jurisdiction on that case. The other track for doing sua sponte en bancs is a quieter, more internal process. And that's where a panel prepares a decision that is going to conflict with a prior decision. And any one of our 12 judges can raise their hand and say, hey, I don't think that what we're about to do here is consistent with past law. In that instance, we handle the entire thing internally. We get to the point where the opinion is otherwise on its absolute last step. It's ready to go out the door. There's no voting to be done at that point. The panel is resolute in their resolution of the case. And then we'll do an internal en banc process at that point, and it could result in an en banc opinion as appropriate. But that's the alternative route.
We got 1 minute. Anything else you want to summarize?
To summarize, the again, only 2 to 3% of these are successful. They will delay your case a decent amount of time. So if you're filing these and you think it could arguably be frivolous, I would encourage you not to. We have a good number of filings, not so many from the attorneys, but definitely from pro se litigants that are rather frivolous or close to frivolous. And again, when you file an en banc that is just not a good conflict argument, you're putting that in front of all 12 judges. And so that's a quick way to sort of
What's your recommendation?
build a
on
reputation.
filing
I would always file a brief in opposition. You don't ever want to leave the court. If you're a litigator on the other side, you don't ever want to leave the court with just one side saying, hey, this is a conflict and you need to resolve it and you need to resolve it in my favor. The entire case can get flipped on that. It can be very important. So if you're a practitioner on the other side and oftentimes you've won on the original opinion, you're going to want to defend it and file a brief in opposition and argue, hey, this is not a conflict. The alleged conflict cases are distinguishable because of X, Y, and Z. Don't take this case.
You don't get a reply in a non-bond, but for a regular appeal, please file a reply brief. They're really important. That's my sweet message of the day. Any other? Oh, yeah.
Judge and Jim, is there a provision in the rule that provides for frivolous conduct when filing the en banc when you know it should not be filed?
No. So the question was, do we have a provision in the rule regarding frivolous conduct in relation to en bancs? The answer is at present, no. Usually we read those motions out fairly quickly.
There is a rule 11 and then we have a
There is.
rule 2.
Yes, you still are bound by rule 11. You should not be filing frivolous motions. It's not a second bite at the apple. It's not I want all 12 judges to review my case. And the judges, they recognize when you file a motion like that. So it can be a negative way to build a reputation if you file frivolous en banc motions.
Well, thank you, everyone.
So thank you, Judge Sheehan and Jim.
We're gonna take a 15-minute break. I think we're just a couple minutes behind schedule. So if everyone can return by 10:47, there's coffee and water behind us. Thank you.
But